Okay. Maybe the participants are in here already. Okay, can somebody wave their hand if they can see me? Thank you. I appreciate it. And you can hear me too, right? Yes. Okay. So always, the first time we start this, there is some jitters and things that go wrong or that we are learning. So we're trying to make sure right now that we have the live transcript going. So far, I think it's only working for me and not working for Jenna, but I'm going to get started anyway because we have so much to talk about and very little time. So welcome. Thank you so much for being here. Welcome to Special Needs Awareness Month. There's a lot going on in the disability world in the month of October. There's a bunch of primary diagnoses that celebrate this month. There is Special Needs Employment Month or Disability Employment Month this month, and many more things. So in general, this is the month that we celebrate our diversity of being a person with a disability and also really taking a look at life planning and all the things that go into that. So as a gift, I wanted to do a webinar series for some of my popular presentations that I get asked to do around the country, and most especially here in Massachusetts. My name is Annette Hines. If we haven't met before, I'm an attorney, an author, most importantly, a mom, a podcaster, and just a prolific speaker. I am a person who is trying to connect our community in so many ways. And one of the things that I really love to do is share information, resources, and supports. So I found that being a lawyer was not the ideal way to do that. It helps some people, but not everybody needs a lawyer. And not everybody is in Massachusetts. So the way that I started many years ago, reaching out to the community and sharing my expertise, information, supports, resources, etc., was to start talking to all of you. It started in small little conference rooms where 8 or 10 or 12 people would get together. And it just ballooned from there to presenting to 300 people at doing a keynote, or writing my book about my life with my daughter Elizabeth, writing articles, and just making sure that the information gets out in as many mediums as possible, because some people listen, like me. I'm a dyslexic ADD person, so it's better for me to hear things and sometimes to picture them visually, but not necessarily to read. Some people love to read and digest. Some people prefer learning in groups. Some people would rather study things and learn on their own. So we are trying to bring this information in as many ways as possible. I want to introduce you to Jenna Cooley, who is my right-hand person. She is assisting me with all of the dissemination of information and resources and supports. She's going to be your right-hand person for all of these, I guess you call them marketing efforts. I call them networking efforts, because we don't really do much sales when we are, presenting this information. And Jenna, do you want to introduce yourself?
Hi, everybody. It's great to have you here tonight, and I'm just really honored and thrilled about this opportunity to support all of you with this and to be here with Annette tonight, sharing our passion and our mission.
So some of Jenna's words are getting transcribed. That's good. The reason that we are recording this is because we will post the video after. And if you signed up for one, you signed up for all 4. And we don't expect that everybody's going to make it every single time. So we're going to make the video recordings available to you, as well as the presentation available to you through YouTube, and also through our information disseminator, which is a program called Active Campaign. So it will get out to you a thank you for coming tonight and also the materials that we presented. So let's get started. And today we're talking about special needs planning, which is part of estate planning. You can't really dig into special needs trusts and special needs planning until you understand sort of the larger concept of estate planning and what that means for you and your family. And then at the end, I will make sure to leave time for some questions, and we will chat about what's coming up next for the rest of the month. So let's get started. Okay. All right, and of course, the first thing that happens, there we go. All right, so this is the legal disclaimer that I need to give you, which is that you are not my client and this is not legal advice. This does not start an attorney-client relationship. I'm sure you know that already. Okay, so whenever I start working with a new client or I give a presentation and I ask people, what does estate planning mean to you? Inevitably, the most common answers I get are something about a will and something about tax planning. And that's most people's really the limit of their knowledge when it comes to estate planning. What does it do? What is it for? Well, those things are important and they are part of an estate plan, but they are not the most important part of an estate plan. The most important part of an estate plan is actually developing your goals. What are your goals for your family? And that means, what are the goals to take care of your people that you love? And what do you want to have happen to your stuff? Because really, what happens in probate or going through a planning process is to figure out what goes where and who's going to own it and how people are going to be cared for and who those people are going to be. So in our world, we call that your circle of care. It's part of the many people who step in to support. Your circle of care is full of supporters. That's a general term that is the hat that somebody's going to wear if they are participating in supporting a person with a disability, someone in your family, maybe you. So why do we plan? Well, we plan because we want our goals to be accomplished. We want to have a say. We want to have the only say in what happens to us, our loved ones, and all of our stuff. So what happens if you don't plan? I think most of you probably know that we have state laws in every state, and those state laws are going to dictate what happens. And that means what happens to people and what happens to stuff. A probate court judge in your state is going to have the final say. So sometimes that means that people that you don't want or don't know may be put in charge of a person you love or of distributing your assets. Assets can absolutely end up with people that you don't expect. And of course, there may be foregone opportunities to do some tax planning and to do some asset protection. So these are just some of the goals that might get set up in your plan. And if you don't set a plan, then you won't have the opportunity to take control and take charge. As a special needs parent myself, I can tell you that control was so important to me. I really needed to assert control where I had some, because there was so much of our life that was out of control and that we could not control. So I want to tell you a little story to give you an example of how things could go awry if you don't do your planning. Back in the day, many people in my community, an Italian community, would plan by setting up joint bank accounts with their 8 children, say, and many of the little old Italian ladies in my neighborhood who were widowed would have $10,000 or $20,000, and they would divvy it out into all these different savings accounts, and they would put one kid's name on each account. And because it's a joint account, the person who, who was jointly on that account with our planner, our little old Italian lady, would inherit that. It would be a joint account with survivorship rights. And so when our little old Italian lady passed away, the remaining person who owned the account just owned the account. It's a simple and straightforward way to do planning, but a terrible way to do planning. What happens is when that little old Italian lady gets older and sicker and needs to start living on some of that money, she may not pull the money out equally. And her division of assets that was supposed to be equal and unified has now completely become unbalanced. And sometimes the assets grow at different rates. So you may have an IRA account, a retirement account that has one person's name as a beneficiary, and that's invested and growing. Somebody else may be on a CD, and that is not growing so fast. So you see, the plan might start out balanced and fair in the mind of the planner, our little old Italian lady, but it can go completely astray. You can use documents to divvy up the assets in a much more reasonable way, and that's what we're talking about today. Here are the most common documents that people will have in an estate plan. They're going to have their will. They're going to have trusts if they are doing a plan for more than $5. They're going to have our incapacity documents, a power of attorney, a healthcare proxy. That's what's known as a medical power of attorney in our state, in Massachusetts, and every state's going to have a little bit different language, and a HIPAA authorization, which is a medical records release. And then there's often some form of nomination for guardians and conservators for either minor children or incapacitated adult children. And that's very important in our world. So what does a will do? Would you be surprised to find that this is absolutely the least important document that you're going to sign when you sign your estate planning documents? It needs to be there. It's the threshold document, but it doesn't control much. It nominates a personal representative of your estate. We used to call them executors. And it can nominate guardians and conservators of minor children or incapacitated children when you die, but it doesn't help you while you're alive and unable to care for your children. And it specifies distributions. So this goes here, this goes here. But not many of your assets are actually going to be controlled by your will. Many people believe that avoiding probate is the most important estate planning objective. It's actually the least important. It's definitely one of the goals that people will cite when they're doing an estate plan, but avoiding probate doesn't protect your family. And that's where everybody's mind and heart goes to when they're doing an estate plan. Sometimes we even deliberately want to have a probate. And that would be in an estate planning 102 class, not an estate planning 101 class. So what matters most in planning is to get your goals satisfied, maximizing the odds of getting the most of what you want and the least of what you don't want in your plan. If you follow that rule, then you can employ all the tools that we're going to give you, and that will get you there. So what is the probate process like? Let's make sure we understand that. You essentially, in every state, are going to petition your court to have a will allowed, and a PR, personal representative or executor, is going to be appointed. That person's in charge now of marshaling the assets, figuring out what you have, taking an inventory, then giving notice to creditors and to heirs at law and beneficiaries. Those are different people under your plan. But the probate process started as a way to do two things. Primarily, first and foremost, to give notice to the people that you owed money to. So before the assets left when you died and went to your relatives or whoever you wanted to leave them to, your creditors had a bite of that apple to get satisfied on their claims. And secondarily, it would be a way to transfer title to property. When you die and you own property, whether that's a bank account, the coins in your drawer at home, or a life insurance policy, anything like that, any kind of asset that you own, your home, it needs a new owner when you die. An asset cannot be without an owner. And the probate process is a way to transfer legally that title to the next owner. Okay. So also the PR will pay income and estate taxes if there are any. It pay appropriate debts of the decedent if they're proper, and make finally distributions to the beneficiaries under your will. At that point, they'll file an official account and close the estate. And that will depend, how much work that all is will depend on the size of the estate. And that's very important because you can do great planning to minimize what actually goes through probate, avoiding the probate process. So a will may control some, all, or none, very little of what your assets are at your death. People will often ask, so what is a probate asset? It's any asset that you hold individually in your name, solely you. It is a lot easier to talk about what does not go through probate. What's a non-probate asset? And I promise that this is all very important because it's leading up to our conversation about trusts. Any assets that are held jointly with another surviving owner, at least one surviving owner. So I mentioned those joint bank accounts with my little old Italian lady in my community. Those are assets that will not go through probate. Any asset that's owned truly jointly, like, husband and wife owning a piece of property together, or spouses owning a piece of property together, how those assets are designated, if they are designated joint with rights of survivorship, means it avoids the probate process. I own that bank account and my husband owns that bank account. We each own 100% of the bank account. And when I die, my husband still owns the bank account. There's no need to transfer title. If you remember that this is a process for finding the next owner of that asset, it will become clear to you that you don't need to worry about the next owner because there's still an owner of that asset. Any assets that are contract assets that have a death beneficiary designation, pay on death, transfer on death, in trust for, or something like life insurance, an IRA, a qualified retirement plan like a 401k, a 403b. An annuity often has a beneficiary. Some brokerage accounts will have a beneficiary listed, and same thing with some CDs and some savings bonds. There are all kinds of assets that can avoid probate by listing the next owner. That's a contract. And by that contract, it transfers to the next owner on death. So what we really want to get to today is talking about how assets owned by trusts are not part of your probate process. And again, they are not going to be controlled by your will. So trusts are fantastic. They are not just for Rockefeller anymore. And we have many kinds of trusts that have many purposes. Yes, they can avoid probate if they are funded with assets. Remember, we need to have an owner of those assets. They can manage assets during your lifetime and even long after your death. Some trusts can provide asset protection for certain people that are part of the trust. It can, and this is where we live, right? It can protect irresponsible or vulnerable beneficiaries from themselves. It can provide for charitable intentions. It can reduce estate taxes. It can plan for long-term care needs. We call those LTSS, long-term services and supports, and a disabled person's public benefits. So that's really what many of our families are using trusts for, to do disability planning or special needs planning. So who can be a trustee of any trusts that you have in your plan? It runs the gamut. You can be your own trustee on certain trusts. Family members certainly are the go-to. Friends, professionals like an attorney or an accountant or a financial manager, institutions such as banks and trust companies. Beneficiaries can be their own trustees sometimes. And, a guardian that you've appointed could also wear their same hat as a trustee as well. So what's the most common trust that people are going to hear about? That's the Revocable Living Trust, affectionately known as your RLT. Your RLT gives you centralized asset management during your lifetime. It's readily accepted by financial institutions as opposed to a durable power of attorney, which if any of you have tried to use a POA, you know how complicated it is trying to get the financial institution to accept it, even when it's properly drafted. But trusts, we have great trust law in every state, and financial institutions feel more comfortable with trusts. Unfortunately, they cannot manage IRAs and other qualified money like 401ks and 403bs. But an RLT can also avoid probate if it's funded, and we'll talk about what funded actually means. And it can reduce or eliminate estate tax. So in Massachusetts, we have a state estate tax, and it's one of the lowest in the country. There's 2 states, Massachusetts and one other, that is at the lowest threshold in the country for estate taxes. Federally, the estate taxes, the threshold's very high right now, and most families I meet with don't have $24 million of assets between the couple. So we are usually not talking about federal estate taxes, but we're talking about state estate taxes, and not every state has an estate tax. Okay, so what else? It provides for succession of management, meaning that we can say, I want this one as a trustee, and if that one can't do it, I want this one, and this is how I want the whole process to go for choosing the next successor trustee. And these trusts can be extremely flexible. You can dream it and we can draft it. We may not always want to draft things that can sometimes be impractical, but there's truly almost no restriction. It can provide for that lifetime asset protection for your beneficiaries. It cannot provide for asset protection for you. If you are establishing your own trust, a self-settled trust cannot be kept away from creditors. Otherwise, we would all take all our money, put it in trust, and never pay our bills. And that's just not how that works. But we can, through an RLT, provide asset protection if we want to for our beneficiaries, namely our kids. And this is a gift that only you can give them. As we said, they can't take the money you leave them and now self-settle a trust. Not in our state and not in most states. And self-settled asset protection trusts they're rare. There are a few states that do them, and they're complicated. Okay, and we talked about eliminating estate taxes for your generation, but also we can do that for subsequent generations as well. So what doesn't it do? I get this question a lot. When I say it doesn't provide asset protection for the creator, it also doesn't protect against long-term care costs. So many people will come to me and say, oh my God, Annette, I'm so worried about the nursing home. The nursing home's gonna steal all my money. So first of all, I want to challenge you to think a little differently about that, because the nursing home is not taking all your money. They are charging you for a service that they are providing, just like your doctor, your dentist, your lawyer, your accountant, etc. There are ways to do planning that allows you to collect public benefits to pay for your long-term care needs if you need care at home, or if you need care in an institutional setting like a nursing home. But you cannot do that with a revocable living trust. You essentially have to do some planning that takes away all of your ownership of your assets. You can't control them anymore. So that's a conversation for another day. But generally speaking, it's important that you know that you cannot do asset protection planning or long-term care planning for yourself within this RLT. If you are single, not married, our government does have a penalty basically against single people. You can't use it as a vehicle to save estate taxes. And it doesn't affect the grantor or the creator of the trust, the funder of the trust, income taxes. Okay, so let's talk a little bit about incapacity documents, and then we're going to jump into special needs trusts. What are incapacity documents? They're documents that allow a supporter, there's that word again, to come and step in and assist you when you need help. A power of attorney, a healthcare proxy, or a power of attorney for medical decision making, whatever you call it in your state, and a HIPAA authorization, which is a sort of a blanket medical records release. And also, if you funded your RLT, that's also an incapacity document, because when you cannot be your own trustee, you have a mechanism for someone to step in and manage your assets in this trust. So let's talk about powers of attorney. Every state has a law that governs the powers of attorney, how they're drafted and how they're governed. It's in our state and in almost all states, a present power. What that means is you, as the principal who signs the document, you have the same power that your agent has. I just had this conversation with somebody today. It does not mean that you, as the agent, take over for the person who signed it and who gave you that authority. You have the same authority, and unless and until they become completely incapacitated and unable to make their own decisions, their decisions always trump your decision. So this is a supporting document, not a legal authority controlling document. Even with a revocable living trust, it's important that you understand that you still need a POA, because some assets are not going to be able to be owned by that RLT. And those are going to be income streams, and they're going to be anything related to retirement assets. It's really important that your power of attorney is not cookie cutter. Many people want to grab a form off the internet, but that may not be the best form for you. You may need to really think about the powers. Again, I had a conversation with a client today, and we were putting a power in place for her sibling. And she said, this is so much more robust, longer, etc., than the one that I had for my mother. And I said, yes, your person that you're supporting has a lot more needs. And there are a lot more things that we need to consider in planning out all the powers and authority that you may need to exercise on their behalf. So it's important to not have a cookie cutter document. And that's the same for your medical power of attorney or your healthcare proxy, whatever it's called in your state. This is a springing power. It springs into place when someone authorizes it, and that is usually the medical professional. This is not usually effective for day-to-day decision making. It's not a form that you put in place today and tomorrow you're suddenly a supporter making all the decisions. That's not entirely correct. Technically, it could happen because the standard for capacity or understanding to sign the document is lower than the capacity to make many medical decisions. So technically speaking, you could sign a document today and tomorrow it could spring into effect. But usually that's not the intent and that's not what it's for. It's really meant for people to use it as a supporting document when and if the doctor says this person cannot make their medical decisions anymore, or they cannot make this singular medical decision. For example, let's compare two cases. One with someone who has advancing dementia. They hit a point where that healthcare proxy or that medical power of attorney needs to be enacted, and it's put into the person's medical record because they've come to a point where they can't make any more decisions for themselves. Or you may have someone who has an intellectual disability that can make a lot of day-to-day decisions, but then something tragically happens to them where maybe they have cancer and they have a treatment protocol and a surgical intervention that needs to be considered. That may be beyond their ability to understand all of the ramifications of one treatment plan versus another. And a doctor may decide that they need to enact or to put the power of attorney and the medical power of attorney in the person's chart to make a set of decisions. And when the person is able to regain capacity for the general day-to-day, when the crisis has passed, then the torch passes back to them. I hope that's easy for you to understand. I hope that makes sense for you. HIPAA authorizations are very simple. They are not decision-making documents. They're information sharing documents, and they are authorized immediately. So it's a great form for many of us who are supporting a person with a disability because it allows us to share information as a two-way street with physicians and sometimes with state agencies as well. Okay, some other documents that we talk about occasionally in a plan: advanced directives, DNRs, anatomical gifts, living wills, and the like. In Uniform Probate Code states like Massachusetts, and there are many of them, you can appoint guardians for minor children. This is not a mere nomination, and that will take effect on your incapacity or your death, as long as it's done in a separate writing. This is why just having this nomination in your will is not enough. You need it to happen in a separate writing so that if you become incapacitated and you can't care for your children, somebody can step in. Your will doesn't come into effect until you die. We need to cover all our bases. You are much more likely to be incapacitated at a younger age than to pass away. So nominating guardians for incapacitated adult children can also be done under the UPC, and most states have enacted this piece of the UPC. And unfortunately, it is a nomination, it doesn't go that extra mile to be an appointment. And what that means is, in the event that you become incapacitated or you pass away, that nomination will be honored by your probate court unless there's a darn good reason not to. In traditional states, there's only nominations effective at death. Nomination will be by will. Okay, special needs trusts. This is what we're all here for. They're governed by rules set out by you. They hold and disperse assets for a beneficiary that has a disability and or some kind of special need, special healthcare need. We sometimes see these for people with addiction issues and so forth. There are two kinds of special needs trusts. I like to say there's two flavors. There's chocolate and vanilla. They're both great. We have third-party trusts, which are funded with other people's money. So we often will talk about a trust and decide what kind of trust we need based on whose money is intended to fund the trust. A first-party trust or a self-settled trust is funded with a disabled person's own money. Why are special needs trusts so important? Why are they so special? Because any assets that are in these trusts, if properly drafted, do not get counted for those public benefits asset tests. Many of you will understand what I mean by that. There are some public benefits, some Medicaid benefits, and some Social Security benefits, namely, and there are others as well, but those are the two main ones that have an asset test. You cannot have assets more than $2,000. That is a little tiny bit of money. And most of us want to protect our, vulnerable family members by planning for them and leaving them money to supplement whatever the government is giving them or what they can earn themselves. So not only can we meet that public benefits asset test by disregarding assets in a special needs trust, but we can also protect assets for vulnerable beneficiaries, both from themselves and for others. So the third-party trust actually offers creditor protection, divorce protection, and protection from other threats as well. What makes a special needs trust so special? So your person must have a disability for a first-party special needs trust, a self-settled trust, but they don't need to have a disability, a documented disability for a third-party trust. You have to have language in your trust that talks about supplementing, but not supplanting, not taking the place of public benefits. These trusts are meant to supplement, not supplant. So technically speaking, under our statute, this language is not required to be in there. But if you don't have this language in there, you are going to get challenges from public benefits agencies that you have to turn these trusts over to. Excuse me. Okay, gonna have a little of my tea. So does that mean that you can never distribute money, assets, when it impacts or affects public benefits? The answer is no, 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 no. Your trust should be flexible. Sometimes it's okay to affect public benefits. You don't want to tie your trustees' hands. For example, as you all may know, I manage a lot of trusts. And what happens sometimes is we can't always distribute for the things that we want to pay for and avoid an impact, such as a vacation. So we send one of our beneficiaries on a wonderful vacation. They're on SSI, and any distribution of cash out of this trust is going to dollar for dollar reduce her benefit that month. But our beneficiary can't save enough money to go on vacation because all she has is SSI. And it's impossible to purchase a hotel stay, food and souvenirs and a plane ticket and a rental car by doing everything through the trust and having the trustee pay for everything directly out of the trust. So we make the decision that we're going to take a certain amount of money, distribute it to her, and she is going to lose her benefit for 1 month. And that's okay because it suits the purpose of the trust, which is to supplement things that she can't pay for herself with public benefits, like a vacation. Okay. So that gets us to the wholly discretionary standard for trustees to make decisions, not what you might see in a, more of a general trust, which is this HEMS standard. HEMS stands for health, education, maintenance, and support. You never want to see that language in your trust document. The distribution standard is the paragraph or 2 or 5 that tell your trustee what can you spend the money on and how do you make these decisions. This is the guiding light for the trustee. The document tells the trustee what they can do and what they can't do. Your trust should say sole and absolute discretion to the trustee. This is the thing that makes family members setting these trusts up really anxious, because a true discretionary standard, sole and absolute discretion, means that your trustee can refuse to pay for housing, food, gas in their car, anything. They can be unreasonable. There's no reasonable test for sole and absolute discretion. But what sole and absolute discretion does is it takes every decision out of the hands of the beneficiary, and that's what makes these trusts work. So the beneficiary should never have an opportunity to demand a distribution. And if you have a standard of HEMS, health, education, maintenance, and support, that gives the beneficiary a demand right to ask for support, to ask for maintenance, to ask for healthcare, to ask for education. You can't have that, or your trust will be a countable asset, and everything in there will disqualify potentially your person from public benefits that they need. And it also needs to have a spendthrift clause, and that's the clause that says that the assets cannot be alienated, they're not available to creditors, and that's only for third-party trusts, okay? So these are the kinds of things that come up all the time in conversation about special needs trusts. Well, my child or my adult person that I'm caring for is not on benefits right now. I don't know if they're ever going to be on benefits, so I don't think I need a special needs trust. However, these disability trusts are wonderful for asset protection too, the third party kind. And there are a lot of good reasons to have a trust, even if there's no public benefits involved. Frankly, many of our people who could handle their day-to-day life are not going to be able to handle, $300,000 if it drops in their lap. They're going to be at risk from themselves, from others, etc. And then people will say to me, well, there is a stigma associated with a special needs trust. Well, I don't think so. You don't have to call it that. And frankly, most of our people have been through special education, they belong to special groups, and they're kind of outed already. Trusts are expensive, they're difficult, they're burdensome, I don't understand them. Yeah, that's kind of halfway true, but it doesn't have to be a stop. It doesn't have to stop you from moving forward with the plan that you need. You can learn, like being here, about special needs trusts and how to manage them. And you pay for a trust one time to get drafted, and then there are potentially fees of managing it, which we will get to in the last session of this series. So third-party SNITs are generally used in parents' estate planning, sometimes siblings, sometimes other family member, loved ones, grandparents, etc. And as we talked about, it's meant to provide supplemental funds for living expenses that are not covered by other sources, but you can use it for anything that you see fit. Anyone can establish them, and there's no age restrictions to establish it or fund it. This is fantastic. It is the best thing since sliced bread. It's a living document, living SNIT. So others can contribute during their lifetime. Many people can contribute. And as we discussed, the trustee has sole discretion over distributions. A self-settled trust, let's dig in a little bit more. It's established only by a certain group of people under the statute. And these are federal rules, not state rules. So it can only be established by a disabled beneficiary themselves, if they have capacity to do so, a parent, a grandparent, a legal guardian, or you have to go to court and get a court order. And what is it funded with? Why would we need this? Well, sometimes you have an accident where there's a settlement coming, and that is the disabled person's own money. Sometimes Great Aunt Ida forgets or doesn't understand that your person has a disability that will be impacted by inheriting, and lovely person that she is, she leaves $50,000 in her will to, your son, your sister, etc. Sometimes we find assets later that we didn't realize the person had, like, oh my God, these awful savings bonds. They're the bane of my existence. They always come up. Overflow, if you're not spending your SSI or SSDI money. Child support and alimony can actually go in there. It's a little complicated, but it can, and then it won't count as income against you or as an asset accumulated. UTMAs and other types of accounts like that. And parents and grandparents can use this for long-term care planning. This is a very complicated area of law, but a self-settled trust can be used for a parent to funnel all their assets, and then the parent becomes qualified for Medicaid to pay for their long-term care needs. Unfortunately, this trust is not the best thing since sliced bread. It's great when you need it, but it has something in there called payback provisions or estate recovery. It can only be established and funded until your person is 65. And every week I have somebody come to me over 65 wanting to establish a special needs trust because their 90-year-old parent just passed away. And there are also pooled trusts called D4C trusts, where you can join a pool as opposed to having your own separate trust account. So talking about trustees, this is the hardest decision that people will make. And I'm just about finished, so if you've got some questions, I want you to start putting them in the chat now. So the trustees' responsibilities are to invest and manage assets, and usually we will have somebody, have a professional doing that, like a Merrill Lynch or UBS. Distributes funds in accordance with the rules of the trust, keeps the books and papers and files tax returns. And with a special needs trust, it goes further than that. We'll often be hiring advocates and care managers, et cetera, as needed, and really understanding the impact of every distribution on public benefits. Every public benefit, like housing or Medicaid or Social Security, have different rules in the way that they look at trust distributions. So it is important to understand all of that. So parents often need guidance with this, as does anybody establishing these trusts. And a lot of times they'll go to the siblings right away as their first thought, a family member. Well, Uncle Bob is really good with money. He's done great in the stock market. Well, Uncle Bob's, investment for himself may not be appropriate for investment for a beneficiary who's vulnerable. Banks and trust companies and professionals, we talked about that a little bit earlier. Sometimes you can have parents and family members with a professional or, having some sort of role. We often call that a trust protector role. And the cost of a professional trustee can be well worth it because they are taking on the burden. So what assets go into your trust? Well, just about anything you own. And I wanted to just talk about able accounts and secure really quickly so that we can get to questions. Congress enacted the ABLE Act in 2014, and it was adopted by most states by now. And at this time, actually, there is an ABLE account available in every state. There's not an agency in every state that manages ABLE accounts, but there are many states that have an ABLE account available to anybody in the country. So it has contribution limits that are tied to the gift tax exclusion amount every year. So that's $16,000 this year. And if you're working, you can also put in an additional amount from work income. You can only establish one if you were disabled prior to age 26. We're trying to get that raised now. The cool thing about these are that the earnings inside are non-taxable. The transfer in is penalty-free. The money grows tax-free. The money, for the most part, comes out tax-free. So it is a triple benefit. You can only have distributions for qualified disability expenses, and there is payback provisions here as well, just like a self-settled trust. So in 2020, we got the final ABLE regulations that told us exactly who could establish it, what qualified disability expenses are, and any that are incurred but not paid before death could actually be paid post-mortem, as well as a funeral, which we cannot do with a self-settled trust. So these accounts can be huge. Secure Act is all about retirement benefits. So just in brief, because this is a complicated issue, now qualified special needs trusts do not have to pay attention to the 10-year rule. We know that we are paying in our money and resources from our income pre-tax when we are funding retirement plans, for the most part. Roths are a different story. And that money has to get taxed at some point. And we had been doing great planning. We were able to stretch that out like 2 generations, 3 generations. Well, the government put a stop to that because they want their tax money and they want it now. They don't want to wait 100 years. So they have decided that there's a 10-year rule and there's very few exceptions. All that money has to come out after you die within 10 years. But one of those exceptions is disabled and chronically ill folks, but also qualified special needs trusts, because if you are disabled, you will likely need public benefits and therefore you cannot have an inheritance. Okay, so this is a huge savings. I have a slide here about our group coaching opportunities, and we have wonderful opportunities for online virtual learning. And this means that you can do this at an affordable rate. It actually costs less than coming to see me for 1 hour. So I hope that these will be helpful to you and that you will be able to use them to promote your learning and to be prepared to work with your professionals and be efficient in that work. Okay, so as I said, you are going to get these slides, so you will be able to take a look at this more closely. And Ivy can answer, and this is Ivy right here. She would be happy to meet with you and answer any questions you have about these programs. Okay, so I am going to look at the Q&A. Can a person have both a third party and a first party special needs trust? Excellent question. Yes, and we want you to have both. Because when you're doing planning as either the disabled individual or as a family member establishing the third party trust, you want to use the same trustees and the same remainder beneficiary scheme that you have. You want it to match up with the rest of the estate planning. So important. Thank you for asking that question. How will my children's caregivers know that there's a SNP? Will group home staff know how to ask for money? Will the trustee, not sure who that will be called for requests when my kids need something? Yes, yes, and yes. We want you to develop something called a letter of intent. And that is a non-legal document that talks about everything that you've done in your planning and who to notify and who to talk to about what things. Most of our clients don't actually get around to doing this. And there's, it's hard to get people to work on that letter of intent. but it's up to you to talk to your agents, your supporters, the people in your circle of care who are taking on these roles, and make sure that they understand their role in the plan and what to do when, where the documents are, who to call, and the group home staff will definitely know. We often encourage people to have a sort of a go-between care manager that can help with these things. I think my kids' SNITs are irrevocable. So that is often the case. We will do irrevocable so that anybody can contribute, and that's for tax purposes. It's a little bit more than I can go into today, but if you contribute to a trust that you've created and then someone else contributes to that trust and you have the right to revoke it and take the money out, now all of those assets are includable in your taxable estate. So it's a longer discussion, but tax planning usually requires us to do irrevocable SMTs. That's not a problem. Okay, adding to the above, can they have an ABLE account with other trusts? Yes, an ABLE account, just like your special needs trusts, are one tool in the tool chest. So we want to use that in addition to ABLE accounts can be so great because they allow a person to save their own money, and this is just like a bank account with that person's name on it. They own the account. It's not a trust and it's not complicated. It's a little more complicated than a savings account, but not much. And it allows the person with a disability to save their own money and to manage their own money. We love to use this as a training tool and as a vehicle for self-determination and independence. Okay, those are the questions. Does anybody have any further questions? I would love to answer them in the 2 or 3 minutes we have left. This has been so great. I love, love, love doing these things. So I'm so glad that you were able to be here. Thank you too, Christine. I'm so glad you were able to be here. And I really appreciate you taking your time. I know it's dinner time for many of you, and it's not always easy to jump in. Remember that we have additional supports and services that are cost effective and efficient and will help you get prepared for the things that are coming. Our special needs transition masterclass is this is my life's work. I've always wanted to launch this. I'm so glad it's out now. And we have a cohort going through right at the moment. And also I'm about to launch the special needs planning online class. The course is something that you can do on your own, and you can use it to get prepared to work with your attorney. You'll understand the terms that they're using, and you'll know what choices you want to make for your circle of care. Okay, let's see what else we have. All right, so Jenna's putting in the chat that you're going to receive an email tomorrow with follow-up and contact information, and we appreciate you joining us. We hope to see you next week. Tamara, what is the typical cost to set up all these legal documents or arrangements? Oh my gosh, well, you know what attorneys say all the time, right? It depends. And it depends on a few things. How complicated your situation is. Mind you, every person comes to me and tells me that they have a very simple estate plan need. Most people who have a disabled person who's a beneficiary has already, gone into that next level of complexity. If you have a divorce, if you have specific kinds of assets that make planning a little more challenging, like you own your own business, you're a consultant, you're running some landlord tenant, rentals out there. These are things that can add to the cost and the time and complexity that it takes. You will get what you pay for. That's the same with any professional at all. And the cost can really range. I would say pick a planner who listens to you and who's interested in what your goals are, not somebody who's giving you a form to fill out and wants you to just show up after they've typed everything into your documents and hands them to you to sign. You really want to understand what you're doing And again, that's why I created this course, so that people can learn what exactly it is that they are putting in place. What are they doing with this estate plan? What does it mean? And how is it all going to work? One thing that happens a lot is people have a lot of questions about, how does this really protect the person? How does this work? And, we cannot, as lawyers, spend the hours and hours and hours that it would take to educate you about every phrase and every paragraph in your documents. But we can give you an overview of the mechanics of your plan and how it's working for your disabled child or your sibling or your parent even. Okay, thank you. We are going to sign off now. We really appreciate it. Jenna, could you press the recording button and stop
I will.
recording?
Thank you all.
I'm going to stop sharing, and I'm going to say thank you so much and have a great night. Bye, everybody.